The personal representative has kept the estate open too long. Hi, I'm Darren Findling of the Probate Pro. We're going to cover the notice of intent to close estate administration and to terminate the personal representative's authority. This form comes up when the anniversary date of the letters of authority are nearing 1 year from the date of the appointment, or if it's been open for a full year, the subsequent year on that anniversary date. What happens is the personal representative has two choices. Either they proceed to close the probate estate by filing the requisite documents to close the estate, distribute the assets, and terminate or discharge their authority as personal representative, or they file what's called a notice of continued administration, in which they seek permission from the court to extend the letters of authority for another calendar year. The failure to do one of those two triggers this particular notice. And as you can see with all of the State Court Administrative Office forms, SCAO, this particular form, PC 589, is governed by a statute as reflected by the yellow arrow and a court rule. Let's examine them. MCL 700.3951 provides the process upon which a personal representative can continue their legal authority to serve as the personal representative and extend the letters of authority for another year through the filing of a notice of continued administration. Any interested person can then object to that. For example, if they think the personal representative is simply delaying the conclusion of the administration by filing the notice when the interested party says it's time for you to conclude the administration and distribute. So you have the right to object and demand a court hearing to bring closure to the probate estate. The court rule, which is MCR 5.203, provides for the process for deficiencies in the role of personal representative. So for example, the personal representative has all sorts of duties and required filings through the administration of the probate estate. The presentation or filing of the inventory, accounting, the various notices that occur while they're the personal representative. If the personal representative fails to perform any of those duties, the court can trigger a notice of deficiency, advising the personal representative that they have 28 days, or in the alternative, depending on the time frame, maybe a less amount of time or more based on a court order, to fix or cure the particular deficiency. This process, this notice of intent to close the estate, is part of that deficiency. It's saying, personal representative, you need to take some action here. So let's look at the form itself. At the top, it will reflect the county and the case number and the estate name. Then it provides this very broad notice. And this notice is being sent to the interested parties of the estate. They may be deficiencies under a will. They may be intestate heirs, people that are receiving a distribution when there is no will. And it provides for the personal representative to take certain action within a certain amount of time or risk the estate being administratively closed, which can trigger both a deficiency and sanctions and court expenses relating to their failure to perform their duties. This particular notice provides notice to the interested parties of their rights. It also says that the personal representative can file any of these particular documents within the appropriate time frame under Michigan law, under those particular statutes within that time frame. Now, the deputy register sends out this notice because it's advising both the personal representative and all of the interested parties within the estate of the personal representative's failure to either close the probate estate or request that the estate remain open under a notice of continued administration. Below, there'll be a certificate of mailing that identifies that the probate court has mailed this notice out, and the events then trigger from there because the personal representative can continue to extend the letters of authority for another calendar year by filing under MCL 700.3951, the notice of continued administration, or they can proceed to close the estate, or they can proceed to ignore this. which then triggers an administrative closing and all the penalties that come with it. If you're the recipient of one of these notices, please read it carefully, understand your rights, talk to your probate lawyer to understand that your personal representative is failing to perform their role. And even if it's a personal representative that you're close with and you care about, make sure that they timely file, because if the estate gets closed and you need to reopen it, it's another expense and another process. Here's the certificate of mailing that's signed by the court register that gives everyone notice that the clock is ticking. At the Probate Pro, we're passionate about everything probate. If you've got questions regarding a notice of intent to close estate administration or any probate-related issue, give us a call, 833-PROBATE, or visit us at theprobatepro.com.